All right, I've started recording. Everybody is here. And we're going to go into a brief review to begin, and then we're going to go through the Bill of Rights. And so first, definition of a republic. What is a republic? I'm going to let Teresa give a first shot on this.
Okay, well, it's an artificial construct of three natural types of government: monarchy, aristocracy, and democracy. I remember that much. You know, I'm not 100% sure if it has to have a written constitution.
It does not have to have a written constitution.
It has to have a constitution.
It does.
A constitution. Okay.
It will have a constitution because,
okay, fair enough.
Because that's how they know how the pieces fit together. And so
okay,
even if it's just an understood constitution, there are like the British. The British have a republic. They have they do have a republic, and they have an unwritten constitution. And,
right.
And so one of the things that made America, a front runner, or what it did as one of the first things, was to write the Constitution, which is different than previous republics, except possibly the Swiss Republic. I'm not sure, but at any rate, good. So that's good, and I bet Howard is chomping at the bit to add something to that. But other than that, I think that's good. I think Teresa did a great job.
Yeah.
He's going to add the thing about where it came from, the Latin word or something. What starts with a P. And ends with US, I think.
All right. It comes from the Latin because the Latin were the first one to come up with, to name the thing. And their thing, that government, was a government of the people. And so it was a government that was created by the people. And in Latin, a thing of the people is res publica. Res publica.
So res publica. To remember that.
That's the thing.
Doesn't end in US. Oh.
That's all right. That's all right. So very good. So that's a republic. And our US Constitution defines a republic. Article 1, well, first it has a preamble because it just says, this is what we're doing. And it says, we, the people, are making this Constitution, this government for the United States. And by saying we, the people, are doing that, they are signaling that this piece of paper is a charter making something, and that the sovereign is the people themselves, and they're making this servant to themselves to help them govern themselves. And so they had Article 1, which dealt with the democratic form of government, which Teresa talked about, the three natural forms of government. One of them is democratic, and that is Article 1 talks about the democratic part, which is the Congress. Article 2 talks about the monarchy part of it, which is the president and all of his departments. Article 3 talks about the aristocratic part of it, which is the courts, which are used to take care of those people which cannot take care of themselves. The government lands on top of these people, and they can't take care of themselves. So the aristocracy is there to protect them from the excesses of government. So that's the first three articles, defines what those three branches are, and gives how one works with the other and how they work together and all that. And that's the constitution of those. Then, because we have a very special situation here, we have Article 4, which deals with the states, which are the states that are joining together to be the United States. Article 5 gives the procedure of how you change this thing, because it was their experience with the Articles of Confederation. You were never able to change it because you had to have unanimous consent. So they said in Article 5, what you have to go through to change it. It's rigorous, but it is possible to be done. Article 6 talks about how it is, how this government here is going to be superior in certain ways to the state governments, and gives a few little rules about things that are to be within across the whole country, like there's no religious tests, for instance. And then Article 7 is the final little piece saying, okay, this is what it is, but it has to be ratified in order for it to go into effect. And here's how you have to ratify it. And that's what Article 7 is. So in the ratification, the people looked at that and they said, not good enough. We need to amend it before we're really comfortable with it. They said, we'll agree to it, but only if you amend it. And there were tons of amendments that were suggested, and from those, 13 of them, the first Congress put together a list of 13 of them, and sent those out to the states. The states agreed to, the Congress put together 13 of them, but only passed through 12 of them. So they had 12 of them out there, and the states ratified 10 of them, and that 10 became our Bill of Rights. The first one had to do with how to keep the government under the control of the people. And I'm going to share my screen now.
There's 5 parts to that.
And there's 5 parts to that, exactly right. And it starts with the observation, or the truism, that each of us is capable of making our own observations and making our own conclusions about the way things are and the way things should be. And therefore, Congress is going to make no law respecting an establishment of religion. But if you're going to not make a law respecting the establishment of it, you have to also, you cannot prohibit the free exercise of it, because otherwise that would be making a law respecting the establishment of it, but kind of sneaking in the back door. If you are going to allow the free exercise of it, then people are going to want to talk to people about it. And so that's free speech. If they're going to want to talk to people about it, they're going to want to tell a whole bunch of people about it. So that's free press there. And when all those people get together and they hear about it, and they hear about a certain way things should be or something, they may just want to peaceably assemble. And when they do peaceably assemble, then they may very well petition the government for a redress of grievances, because they say the government is doing stuff that it shouldn't be doing. We want it to do the stuff that we want it to do. And so this is how you keep the government under control. And that was the first amendment that they wanted to this Constitution. They wanted to guarantee that they had a path to be able to keep this government under control of the people. However, they were pretty smart guys, and they knew that it's entirely possible for the First Amendment to fall apart. And so they said, all right, let's have a Second Amendment. And now we're going to do Second Amendment. And Marty, I'm going to ask you to read the Second Amendment there. I'm going to stop you in the middle of it.
Okay. A well-regulated militia being necessary to the security of a free state.
Okay.
Now
that is
preamble.
Is a preamble to this amendment. It's half the length of the amendment, but it's telling you, why are we doing this? Mm-hmm. It's making sure that you understand what it is that we are doing, why it is that we're doing it. And then go ahead, Marty.
Okay, the right of the people to keep and bear arms shall not be infringed.
Good. So it makes the assertion that
shall not.
That it makes the assertion that people have this right. And then it says, so you're not going to infringe upon that. And the reason you're not going to is for the security of a free state, is so that, as I say on the side here, it's another method of keeping the people free. All right, now there have been lots of court cases, lots of opinions, lots of things about this Second Amendment. And as the attorney, one of the attorneys who used to come to our local study group until he passed away used to say, if you try to find a court opinion about the Second Amendment that agrees with your thought on it, you will find it. No matter what your thought is, there will be a court opinion somewhere that
It's all
agrees.
over the place.
So it can be all over the place, and it depends on. And he wrote a little book, which I have now run out of stock, and the only way that I'm actually, selling it. And yes, you have it right there, exactly right. Marty has it. It's called Gunsmoke in the Courtroom. And the only way that I'm selling it these days is just you ask me for it. I tell you to put some money into my PayPal account, and then I'll send you the PDF of it. But Marty already has it. Howard already has it. I don't know if Teresa may have it as well.
No.
Okay.
Yeah.
Well, if you are interested in what it does, is it lists out the 20 most important cases regarding the Second Amendment, going back to state cases, including state cases back to 1822, and the decisions that have been made on the Second Amendment up to 2008, which is as
Heller. Was that Heller?
Heller, and it is as far as Jack got before he passed away. But if you want that, send me an email, and we'll talk about how to get that to you. Okay.
Yeah.
All right. And now the third amendment. Teresa, would you like to read the Third Amendment right here?
Sure. No soldier shall, in time of peace, be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law.
Yeah. So, in time of peace, it's just not allowed. Soldier is not allowed to be quartered in your house. Now, why do you think that?
Because they were doing it all through the Revolution. They just come in, and the British took over the house, ate their food and their sustenance and everything.
Right.
Without their consent.
Yes, and Howard asked, can you hear me? No, Howard, we cannot hear you. So, all right, we're looking forward to you getting your microphone ready or together. Okay, we chat again.
Now, in a manner to be prescribed by law,
Right.
would be, so they say, okay, well, we're in a war, so now you've got to do such and such.
Well,
Is that
and they can say prior to the war, they're going to prescribe this manner, whatever it is that's required. So it has to be by order of the president, and they have to whatever hoops they have to jump through. And then Howard's coming back, and that's done before war. Before the war happens, and then when the war happens, then they can go through this prescribed procedure in order to quarter troops in houses.
So that would be like when they actually declare a war, which we haven't done since World War II.
Right.
Okay.
Right. Well, I would think so. In
Yeah.
time of war.
Time of war.
Okay. These first three amendments we mentioned last time, but I mentioned again. These first three amendments keep the Congress and this government away from, they say things that you cannot do to the people in general.
That's right.
In general, you're not going to infringe on the right to bear arms. In general, you're not going to have a law respecting an establishment an establishment of religion. In general, you're not going to quarter soldiers, except in the prescribed manner and so on. So this is just dealing with the population as a whole. These are things, these are rights that everyone has because they are members of the population. However, they also recognized that that a government can come after an individual. They can decide they don't like somebody who's making too much noise, who's being too much of this or too much of that, and they can go get him. They can go after some particular person. So they realized we're going to have to protect the individual person as well. And so Amendment 4 is just in general, before a person is accused of anything, before a person, when they just suspect that a person might be doing something wrong, when they don't like somebody, they're going to have to still follow certain rights. And these rights are, how you doing there, Teresa?
Good.
Okay.
I know, because I yawned, right?
Yep. So I'm looking.
Well, I don't know what to tell you.
Are you all right with the first
three
kind of being about the people and about dealing with populations in total?
Yes.
Okay. So
Yeah. Yeah.
Okay. So now we're going to get down to protecting an individual so that the government can't come crashing down on some individual just because some bureaucrat doesn't like him. And the first part of that is going to be, this is Amendment 4. So I'm going to ask you, Teresa, to start reading it, and I will stop you at some point along the line.
Okay. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated.
Good. Okay. Okay. So this is now giving you the purpose and why we're doing this, what this is about. It's not quite a preamble. But maybe it is kind of a preamble. That this is telling you why we're doing this. That here's a person, and you can't just go after him because you don't like him. He has to be able, he or she has to be secure in their persons. You can't just scoop them up off the street. In their houses, you can't just barge into their house. You can't just take their stuff and their effects, against unreasonable searches and seizures, against just somebody coming in because they don't like you. Something that the Communist Party would do is they just come into your house and they just take stuff.
The IRS to the conservatives.
Well, we're not going to get into that.
Yeah, no.
I know that I got all these thoughts going in my head on all this stuff and the millions of violations, but I think that's a whole nother class, isn't it?
But the point is that we have this to stand on, that this is what the ideal is. We recognize that there are violations. If we didn't have this, we wouldn't even know there are violations.
That's right.
You're right. Absolutely.
Okay, so a reasonable search or seizure would be, we have to now kind of define what a reasonable search and seizure is. And that's how we get into this next section here. And go ahead and continue with it, Teresa.
Okay. And no warrants shall issue.
Okay, good. Okay, so this makes kind of the assumption that a reasonable search and seizure, there will be a warrant that allows it to be. It can't just be that here's the cop walking down the street. He doesn't like your looks and he starts harassing you. He has to have there has to be some kind of a prior looking at this, and that a warrant has been issued. So he's got something in writing that allows him to do this. So there's going to be a warrant that's going to be issued. And how is this warrant going to be issued? You can just start from "and no warrants" again.
Yeah, and no warrants shall issue but upon probable cause, supported by oath or affirmation.
Good. Okay.
And
So good. So we'll just do for this part. You just got to have probable cause, and it's got to be that somebody makes an oath or affirmation. In other words, the cop says, "I swear this is true. I saw him with the knife in his hand," or whatever it is. I saw,
Candlestick in the library.
So we are swearing to the court that this is true, so that the court will then issue a warrant. And this is one of the problems, like for instance, with the FISA court and the case, because we happen to be doing it right now, or it happens to be in the news and all, was Michael Flynn, not Michael Flynn, Carter Page.
yes,
Was warrants were issued for him.
There was no probable cause.
And well, they had probable cause because they swore oath or affirmation, but the
They were
sworn
false.
oath and affirmation was false.
They're false.
Right.
It wasn't true.
So that's criminal, and that's
Right.
what that one guy has pled guilty to. Was that crime? So go ahead and start from "and no warrants" again. I'm sorry, I keep butting in there.
It's okay.
That's
There's
okay.
4 parts to it, so let's go.
Okay.
and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized.
Good. Exactly right.
All of those things need to be there. It doesn't say
Exactly.
or, it says and. All of those things need to be present for that warrant to issue.
Correct. And if they don't,
Hey, Joel.
So,
and if they don't have those, then it's a faulty warrant. And there are a lot of cases that are thrown out on the technicality, and people get all up in arms. Oh, it's got thrown out on the technicality, ooh, and stuff like that. But usually, what the technicality is because there was a violation of the Fourth Amendment.
Wow.
And we don't want, and if you can violate the Fourth Amendment for somebody that you know is a bad guy, then that means that your Fourth Amendment can be violated too.
Absolutely.
So we have to allow them to be let off on the quote technicality.
Yeah.
All right, so Amendment 4 then deals with a person who's being accused before they're even accused of some kind of criminal activity. And just because some bureaucrat doesn't like him, he's got to go through all this stuff in order to make it legal. Okay, so now we get a guy that is accused. Let's say you've gone through all this stuff and you now have a guy that is accused. Now his Fifth Amendment rights kick in. And Fifth Amendment is, Joel, would you like to start reading that, and I'll stop you at some point along the line?
absolutely. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury.
Good, okay. So I had to look up what a presentment and indictment was, what the difference is between these two. But first of all, let's just say, let's say we have to have a person who is, if we're going to accuse a person and make him go through a trial and all that, particularly for a capital or otherwise infamous crime, he has to, it has to first go to a grand jury. And a grand jury is an old, it's been there for a long time, goes back in British activity back to, perhaps the year 1000 or something. Or probably even earlier than that, old Anglo, old Saxon justice and so on. That before you could accuse somebody, you would have to take the information that you had, and you would have to present it to a group of people, a grand jury, which is not the jury that's going to actually try the case, but it's just all they're there is to look at, does it look like we have a crime here? Because it has to first pass through this first thing. And the grand jury can either, now when a grand jury is impaneled, when it sits down and it starts, its job is to decide if crimes are being committed or not. And usually what happens is the prosecutor or a prosecutor, and I cover this in the chapter on jury rights in the Your Rights book. So the grand jury is presented a bunch of information about some situation, and they say, yeah, you presented enough of a case. It looks like there was a crime there. And then you can go out and arrest the guy, and then we follow through the rest of everything else. Or they don't have to be presented it by the prosecutor. They can go out and find something and say, oh, this looks like a crime. They don't need to have the prosecutor tell them and bring to them what they think is a crime. If they see something that it looks to them like a crime, they can present it. And they say, this is something that needs to be, needs to be taken care of. It's a similar kind of thing when someone goes up to Congress and talks to Congress about, gives testimony in Congress, which is under oath. And then later on, they find out that what he told them, what the witness said was not true. Then they refer that to the Department of Justice. And they're like, it is analogous that they are then making a presentment to the Department of Justice that this guy has committed a crime. The Department of Justice hasn't gone out and tried to find it. They found it, and they're telling the Department of Justice it looks like you got a crime over there. So
right. So at that point, would the Department of Justice or district attorney or whatever level it's at, are they obligated to take the case up because the grand jury said, hey, there's a crime over here?
I think that they are not obligated to, because there is such a thing as prosecutorial discretion, and they can decide not to do that. However, if they don't, and the grand jury really doesn't like that, they could perhaps go to the feds and say, hey, we got a guy here that's not prosecuting stuff that he should prosecute, or some other kind of thing. No, he's not required to do something about it. But if a presentment is made, he doesn't do it. Oh, I don't know. You can go to you can go to the newspapers or whatever. I mean, there are.
Now, on the other hand, so by this, every single time somebody's going to get indicted for a felony, let's say, well, it says capital crime. I'm assuming a felony would be considered a capital crime, or is a capital crime only a
capital
murder
crime,
or something like?
Well, capital crime means death penalty is attached to it.
Okay.
You lose your head. That's what capital means. Lose your head, or otherwise infamous crime, and which felony, yes, that kind of fits.
Okay, so if a guy gets busted for grand theft auto,
Yeah.
would it go to the grand jury first and then go to the court for indictment, or would it just go prosecutor, take it straight to the judge?
No, I believe that will go to a grand jury. The grand jury will get, I mean, the guy will be in jail. And, but I believe the grand jury has to take a look at it, and it may be, there may be differences in different jurisdictions, but it certainly looks like it here, that it's,
Yeah, I mean, you never really hear about that except in really high profile cases that the grand jury is reviewing it or whatever. I don't hear about it about every other little murder or crime that happens in Pasadena anyways.
yeah, well, no, well, when you get a speeding ticket, it doesn't go to the grand jury.
Well, yeah, but that's not a felony or a capital crime.
That's right. It's not an infamous crime.
Yeah.
Right. All right.
Okay.
So we are at the point where we just talked about this. Okay, so you have to have a presentment or indictment from a grand jury, except, Joel, you want to continue?
Sure. Except in cases arising in the land or naval forces or in the militia.
Right. And
when
okay, and the reason for that is because they have their own justice system.
Right.
Okay. I'm sorry. Oh, I actually kind of cut you off there a little bit too soon. Go ahead, continue. I'm sorry.
That's right. When in actual service in time of war or public danger.
Yes. Okay. Yes, because land and naval forces and militia, when in actual service in time of war or public danger, they have their own justice system. Okay, continue, please.
Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb.
Good. Okay. Now this has been.
Yeah.
This has gotten a little bit twisted, in my opinion, because you can have a person who's committed an offense, which is not only a state crime, but is also a federal crime. And you can go to the state court and the state court finds you not guilty, but then the feds take it up and charge you for the same thing. And
O.J. Simpson.
And they say, well, no, it's not really the same offense. And I've seen the court case, the Supreme Court case that allowed that to occur. And it really makes your head scratch as to why they allow that. They just wanted to get the guy. But it's all reasonable and it makes complete sense. It's very, very, reasonable. But it should be that for the same offense to be twice be put in jeopardy of life or limb. He was in jeopardy in the state. They found him not guilty. So the feds take it up under the federal statute, but it's the same offense. However, that's where that sits. Okay. Continue, please.
Nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law. Nor shall private property be taken for public use without just compensation.
Good. So these are all where a person is going to be harmed by the government. This is the stuff that you have to adhere to. This is the stuff that you have to go through. These are the steps that you have to do. So Amendment 4 has to do with before you're accused. Amendment 5 has to do with after you're accused. And now Amendment 6, Marty, I may stop you in the middle of this. Let's do Amendment 6.
How about Howard?
Yes.
Howard,
Can you hear me?
no, Howard, I don't. Yes, I hear you now. I didn't know that you were on. Okay.
Okay.
Thank you. Howard.
Thank you,
All right.
Marty.
You're welcome.
6, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and
Okay.
district wherein the crime shall have been committed.
All right, good. Now, why do you think that they would have this?
So they don't rotted in jail waiting for their court date, like we are now.
All right. Um, who's rotting in jail now?
Well, I deal a lot with small claim stuff, and they've just, I mean, they're scheduling out to February. You know, it's such a long time. It shouldn't take that long. That's just for small claims. You know, in a criminal case, they take 2 or 3 years. You know, and that's a long time.
Well, first of all, a small claims thing is not criminal prosecution,
No, that's true.
and this is in all criminal prosecution.
Yeah, but some of these cases take a couple years.
Yeah, and usually that's because the defense wants to have continuation so that they can do more discovery, so that they can run down witnesses, so that they can find. Usually it is the reason it takes so long is because the defense is asking for continuance. Is usually how that happens. Speedy and public trial, because they used to have, they just grab you, they put you on trial, and nobody would know where you were, and they want to make sure that it's all out in public, everybody knows about it, so that to keep some bureaucrat from just starting to get his way and nobody ever finds out about it.
Yep.
And
Is that Star Chamber?
that's Star Chamber. That's what I was thinking of. Exactly right. And it's by an impartial jury. And this is really important. It has to be in the state and district wherein the crime shall have been committed. Why do you think that's important? What do you think? What do you think they're trying to the problem they're trying to handle with that?
They didn't want him removed to England.
Exactly right. That's exactly right. That's exactly right. And that's the same kind of thing that what the Chinese, what Hong Kong was upset about, and we had the riots in Hong Kong because they were saying anybody that we find, any criminal that's in Hong Kong, we're going to move them to mainland China to prosecute them, and they didn't want to do that. They wanted it in the district where the crime is committed. And then continuing, because now it's going to describe what the district is. So I think
Howard. And to be informed of the nature and cause of the accusation.
Wait.
Back up. Which district?
Which district shall have been previously ascertained by law.
Right.
And
Okay. So this just to complete the thought on the district is that the district, you can't catch the guy and say, oh yeah, okay, this district is now, and then redraw all the lines so that you can end up taking him to England after all, Okay, and
to be informed of the nature and cause of the accusation, to be confronted with the witness against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense.
Good. So he has to be able to, he has to basically in the court, you see, because in the court, he has to be on an equal footing with those who are accusing him. He has the prosecutor who, this is the prosecutor's job. He does this every day. And here's this guy who's a blacksmith. He knows how to blacksmith, but he is perhaps totally confused about how did he end up here? So he has to be informed of the nature of it. He has to be informed why he's being accused. He has to be confronted with the witnesses against him, so that he can ask them, what did you see?
See, that was the problem with the impeachment, is that the witnesses were these unidentified sources, you know?
Whistleblowers, yeah.
Yeah, the whistleblowers, they're unidentified sources. So you're actually never confronted by your actual accuser.
Right, right. And that,
Yeah.
and that's basically why there was no conviction there.
Right.
So, so he has to be informed of this. He has to be informed of why he's being accused. He has to be able to confront the witnesses, and he has to have compulsory process. And what that means is he has to be able to subpoena witnesses
Shown witnesses.
to come for him in his favor. So that if here he is, the blacksmith, and he's being accused of stealing the horse, and that means that he had to have been in this place at this time. However, he wasn't there. He was in St. Louis. So he needs to be able to
All witnesses from St.
compel,
Louis.
compel the the clerk of the hotel where he was staying in St. Louis to come and say, yes, he was in St. Louis. So there's no, so that then people will go, there's no way that he could have, you know, stolen the horse. And he also has to have assistance of counsel for his defense, because he doesn't, it's like, he's too confused by all this. He doesn't know what's going on. He needs to have somebody who's familiar with what's going on help him do this. So that's all the stuff that in a trial, you have to have, you have these rights in a trial to make sure that the government cannot just
Walk over you.
ramrods a certain person because they don't like him.
I have a question.
Yes.
Okay, if it's a whole different subject, that's okay, I get it. You know, all that looting and rioting and BS that was going on and is still going on.
Still going.
A lot, yeah, a lot of those guys were, you know, the word is they were arrested and then they didn't have to post bail and they went back out in the streets, right?
Correct.
And there were reports, well, they arrested 400 people or 100 to whatever. Are all those, let's say in one night, you got, say, 200 arrests. Every one of those 200 get all this? Or is that some other court thing that I'm not?
No, that's no. That's when it goes to trial. They haven't gone to trial yet. And
Right, so
and the question that you're, I think the question you're asking is, how did these guys get out?
no, I'm not asking that.
Okay.
What I'm saying is there's so many of them that did get out. That's aside. That's a whole nother subject.
Okay.
But there were just so many arrested per night.
Yeah.
I mean, can our court system, they have to handle every one of them, right? Is that what it's saying?
Well, they aren't at court yet. They're still arresting them and getting the crimes set up.
So each one of those individuals,
Has to have their due process. Yeah.
okay, that's all I'm saying, because it's just so overwhelming. I'm like, how are they gonna prosecute that many cases?
Well,
You know?
I would think they probably won't. I mean, honestly, hopefully they got a couple people that they know who exactly they are and they can indict them. But I think often in those circumstances, the police will arrest a whole bunch of people just to calm the situation down.
Right.
And then they let them go. So
Well,
whether that's right or wrong, that's my viewpoint on what
Right.
I think happens quite frequently.
well, I will just give you my very specific experience on that. Because in 1969, I was arrested along with 400 other people at San Francisco State College. And there were all 400 of us, and we were all processed, and I spent a night in jail. I actually only spent a half a night in jail because I got bailed out by the Brothers Defense Fund. And as the guy came and got me at, midnight or 1 o'clock in the morning, and he's this great big black dude. And I go, how come you're bailing me out? So it's a Brothers Defense Fund. And as we're walking out, he tells me what we did is we took all 400 people that were arrested, the names of all those 400 people, and we just looked down the list for anybody that looked like they might be black, a black name. And the name John Chambers, you may or may not remember, but at that time there was a band called the Chambers Brothers.
Oh, yeah.
Yeah.
Time.
Yeah,
Yep.
Time, exactly right. Time.
Today.
Yeah, exactly right. And
They were black, yes.
so anyway, I got bailed out, and they took my name and stuff like that. It's an interesting story in
That's cool.
interesting story in itself. But a lawyer handled a number of us. First of all, there were some people who just got picked up, scooped up as part of it, who are actually just students trying to get to class. Okay, and they got found out. And they were like, okay, and they were like, okay, you can go now, because they were just it was a mistake that they just got scooped up. But most of the rest of us, well, a plea bargain was worked out for us, so that I and others pled nolo contendere, which is basically I do not contest what it is you're charging me with. I did what you said, but I don't think it was wrong. And for that, I got like it was like a $60 fine or something like that, and 6 months probation. But since I'm such a nice guy and all that, I would go see the probation guy, and I did that for like 2 months or something like that. And the second time he said, "You're a fine guy. You don't know. You're done. You don't need to, it's over." So, and I paid off my $60, and so we were all individually handled, but there actually was a group of us that were handled all at once as this nolo contendere thing. Okay. I am sure that with regard to riots and stuff, those that they actually have eyewitnesses of, you beat somebody up, they're going to get charged with assault. You actually tagged property, and they'll get charged with, malicious mischief or something or other. There will be other people that will have different charges and that sort of thing. And some of them, and there will be a number of them that will be taken care of in a certain way. And then a number of them will be taken care of in a different way, because they all are kind of the same kind of thing.
Category.
The same category, exactly. And they will, but the reason that they're not in there now is because the prosecutor for Portland thinks that they're all just fine, that they're doing the right thing, that and doesn't want to prosecute them. It will become different when or if the federal government, particularly the president, who has the power to do this, declares that it is an insurrection, and he has to go through an exact procedure, which is not long. Basically, he tells them, he gives them a certain period of time in which to disperse and not do this anymore. Maybe a week, maybe a couple of days, something like that. And if they continue doing it, then he has the power to send in the militia, to call up the militia to join the army and the land and naval forces, but land forces in this case, and go arrest all of them on federal directory charges.
Yeah, they were desecrating federal property.
Well, federal property, but also just because they are violating the civil rights of all of the people in that town.
It's true.
Yeah.
You know, and it is a violation. It's a violation of I think it's Title 18, Section 1981 or something like that. It's basically the civil rights law under color of state law. And see, when he does that, then they can also go get the prosecutor for allowing this to occur under color of state law. And they can do RICO with it, which now the state of Florida, I saw that DeSantis is doing that. He's going to start going after rioters and those that fund them under RICO.
All right.
And Teresa, it's nice.
Yeah, we have a fairly decent governor here in Florida.
Oh, yes, you do. Yes, you do. So, so I think that's anyway, that's what's going to happen. Oh my goodness, I see it's almost 5 o'clock. And we are going to get done with the Bill of Rights today.
Okay.
Okay. So that was number 6.
Mm-hmm.
Anybody else? So you didn't know that about me, did you, Joel?
Well,
Wow.
Not exactly, but I was at the University of Illinois. I wasn't quite as adventurous as you, but but I saw my fair share of activity.
Right.
Power to the people, John.
Right.
Thank you. Yes, it was. Yeah, someday I'll tell you more about that. It was a fascinating little thing. Being bailed out by the Brothers Defense Fund. Okay.
Funny.
Amendment 7.
Marty.
Marty, good. Okay, Marty, go for it.
In suits at common law where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law.
Good. So what this does is it makes it for trial by jury,
Yep.
for common law, and that's your small claims court and so on.
The small claims court does not have juries.
I think that when you do that, when you go to small
You waive it.
claims, even though the value in controversy exceeds $20, I believe they have you sign a thing that says you are giving up your right to jury. You're not gonna demand a jury.
Yeah.
For this, to get into small claims. And it says here that if the jury has the final say.
Mhm.
You know, court of the United States, no court of the United States is able to overturn a jury, except according to the rules of the common law. And there are some times when the jury it's just obvious that they didn't even listen to the evidence. I mean, it's like they just weren't even thinking about it, and the judge can declare a mistrial or whatever like that. I'm not an expert in the law, but
Well, John, you also have jury nullification.
Yeah.
well, what jury nullification does is this does not touch that. This does not touch that.
That's the right of us individuals.
That's the right of individuals to decide on the jury anything you want. You know, any you can decide different stuff. And I have a whole section, like I said, in the Your Rights book on juries and jury nullification and all that.
Cool.
All right, number 8. Teresa, number 8. You got
All right.
Yeah, go ahead.
Yeah, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted.
So you see, this is the rights that the individual has even after the trial, even after he's been found guilty. There's still things that they're not allowed to do to him. So this whole rundown from 4 through 8 is the whole process of before you're accused, and then when you're accused, and then in the trial, and then what has to happen in the trial, and juries and stuff like that. And then even after you get convicted, there are still certain rights. And it's this whole river of rights that flows right through that. The wording of this is very, very similar to one of the sections, one of the points that's in the English Bill of Rights from 1688 that we talked about last week. Number 9 is Joel.
Right? The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people.
Good. So just because we talked about religion and we talked about speech, that doesn't mean that's the only thing you got. There are a number of people that, like, for instance, they look at Roe v. Wade and they say, they discovered a right to privacy, and this is, and they don't like the fact that they discovered this right to privacy. Well, excuse me, that's Amendment 9 right there. The Constitution didn't enumerate it, but people still have the right to privacy. It's not just because it's not enumerated there. Now, there may be other things about Roe v. Wade that we don't
like the right to murder.
And that's
No.
and that's a different story.
Right.
Merely discovering that there is a right to privacy is not a failure on the part of the court. It's actually, it's what Amendment 9 is about.
Well, it could be right to privacy from the government search, following our phone conversations, our emails, that's the whole thing like that. Yeah.
Yeah, exactly right. Exactly.
So Google should stop spying on us.
Well, that's a private company. That's different.
However, Google should stop spying on us.
They should stop spying, but they're a private company. They are not under the Bill of Rights here. They're not part of this.
Although also you do have the right to not deal with Google.
That's right.
And that's the reason why these things are named with government, because you don't have a right to not deal with the government.
If you're within its boundaries, correct.
That's right.
If you are under its jurisdiction, that's right. All right.
Howard.
Howard. No.
Ooh.
Howard, are you up? No, who's up?
I am.
Are you up? No,
Yep.
Joe.
You just
I've only
finished.
read one.
Okay. All right. Howard, number 10.
All right. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people.
People.
Good.
How are the people?
So the people retain certain rights, the people retain certain powers, and the national government is only allowed those things which are in the Constitution. And that spelled that out very specifically. So this was 1791, these 10 came up, and that seemed like, all right, we're pretty good, in business, but some things came along. And so next week, we're going to start talking about, next week, that's right.
You're not here.
We're not here next week. And hopefully I will remember from where I am on Saturday to send out to say, we're not here, and I'll see you next week.
Yeah.
The week after next, yeah?
The week after next, yeah.
So that's the November. Are we in November yet?
No, that'll be the 18th. That'll be like the 25th or something.
Oh, that's right.
All right.
Wonderbar.
Any final comments on this?
Thank you very much.
You're very welcome. It was fun. Remember that this was just a quick overview. You've now read it. You've got an idea of what they are, and you can take any one of these, and you could find a library that's been written on it, and you could lose yourself in
Yep.
in all about what those are about. Okay, guys, thank you very much. I'm going to
Thank you.
Thank
Thank you,
you.
John.
and good. We'll see you 2 weeks.
Cool.
Okay.
Okay,
Sounds
Bye.
good. Take care.
Bye.
guys.